So you may get a request to accept the recording. Go ahead and do so, please. And Sara Mooney and Elizabeth Hendren, thank you both.
Thank you so much. I'm going to go ahead and start our PowerPoint and share my screen here. 1 minute. All right. So we're going to go over the agenda for today. All right. First, Sara is going to talk about a little bit about Sexual Violence Law Center.
Yeah, hi. Thank you, Kaylee and everyone for having us. We're excited to talk with you today about the new protection order statute. As you're working with survivors, we just want you to remember that SVLC, Sexual Violence Law Center, is a resource for you and them. We're a statewide nonprofit law firm, so our services are free. And we work with survivors of all genders and ages throughout Washington, assisting them holistically with their emergency legal needs. So working with them in multiple areas of law, because, you know, as we know, sexual violence impacts so many aspects of a survivor's life. Some of the cases that we regularly work on include protection orders, housing, employment, working with students through Title IX cases, or working with crime victims to ensure their rights are protected during investigation and prosecution phases of criminal cases. Being trauma-informed is central to our service model, along with being based in race and gender equity principles. Specifically to support survivors, we provide litigation assistance. So we take cases for direct representation. We also offer consultation and brief services. We do advocacy work, including policy reform and work with the legislature. We do a lot of outreach and education, kind of like the training we're doing today, and we always appreciate the opportunity to do these. And then we connect survivors with other resources, because obviously we're a legal provider and their needs often fall outside of just the legal system. So with that, I'll let Elizabeth go over our agenda and get our presentation started.
Right. So just quickly, kind of so that you all have an idea, we're going to spend kind of about 20 minutes going through the legislative intent and kind of some high level changes that have happened with the new statute. And then we're going to go through the petition and pre-filing forms together. And please just feel free to ask questions. If I miss something in the chat, Sara, will you get my attention, and vice versa when you're presenting? So just wanted to give that kind of preface with everything. I know we have about an hour. So going forward, I'm going to quickly go through the legislative just to give some background for why a lot of the changes went into effect. For me, that kind of helps better understand a lot of the different definitions and different procedural changes. So just for some background, prior to the most recent legislation, and there's been two pieces of legislation, just to be clear. There was one in 2021, SHB 1320, and then last year there was SHB 1901. Prior to that, and it's all been incorporated in our CW 7105. Prior to that, we had several different statutes and several different processes for protection orders. So we had the Domestic Violence Protection Order statute that went into effect in 1984, the Vulnerable Adult Protection Orders, which went into effect in 1986, Anti-Harassment Orders in 1987, Sexual Assault Protection Orders in 2008, Stalking in 2013, and Extreme Risk Protection Orders in 2016. And there were some inconsistencies between these processes and these statutes that made things kind of confusing. There were issues where sometimes petition for one would actually be eligible for a different one. The court, you know, they'd have to do a whole new petition. And so this new statute is, the intent is to consolidate all of these and to just make the process easier for everyone. And this is also why we have one petition now, which we'll talk about a little bit more in a minute. So I just wanted to direct you, it's here. There's a very lofty intent section in the statute that I think is worth reading. It's quite well written, and it has a lot of just the big picture things that are being addressed with this statute. So I just want to direct your attention to that. But in summary, in addition to updating and strengthening the laws, there was also an intent to provide safety for victims without the need for victims to rely on or engage in the criminal legal system. So that's why there's different issues in 7105 where a survivor doesn't have to have cooperated with police. The survivor should be able to submit evidence other than calling 911 or cooperating with the criminal legal system, because there was an acknowledgement that not all survivors want to do that, and that doesn't mean that they didn't experience abuse. There was also a lot of work around firearms and ensuring that the surrender of firearms is a smooth process that is done to reduce harm because of the acknowledgement of the risk that firearms cause to survivors, particularly during separation in this process when they are still in the hands of abusive people. Also, overarching, clarifying, and simplification of the statutes and the process. There was a lot of advancements in technology, and so now we have, and we're going to continue to have online filing in all counties, electronic service, and remote hearings. I know some counties, and I'll just say too, with some of these, depending on where you are, some of these things were already happening in certain counties, but the issue is that it wasn't consistent across the state. And then also consolidate into a single chapter to improve the efficacy and understanding of the law. I'll also add that there was a codification of case law so a lot of the a lot of the changes to the statute were changes that existed in law, but it was very difficult for pro se litigants to understand that because it was changes that had been incorporated through case law. So those also encompass some of the changes. And overall, just simplification of the process, particularly of pro se litigants, because of the acknowledgement that many people navigating this process are pro se, which I know is nothing I have to tell all of you, and just statewide consistency so that there's not justice by geography. Everyone knows what's going on across the state. So to summarize the two bills, the first bill, HB 1320 in 2021, which was the larger bill, and that was kind of the meat of combining and reconciling all the different protection order statutes. It incorporated relevant case law, as I said. It addressed uses of technology and reduced the burden on litigants. There were several issues that weren't resolved in that session. So for example, with technology, there still were questions about how exactly technology was going to be utilized for all these systems and what the system to then have a companion bill in 2022. There also is a big issue after 2021 about whether or not coercive control should be included in the definition of domestic violence, and if so, how we define that. There were also just a lot of issues that had to be worked out. So there was a companion bill in 2022. It revises some of the jurisdiction issues in terms of when district court can hear cases and how those transfers happen. It standardizes the transfer criteria and process. It added coercive control to the definition of domestic violence, and we'll talk about that in a minute. It modifies service and hearing issues and has just further standards. So there was also an acknowledgement in all of this that, and an intent to have trauma-informed care for people navigating this system, the legal system, and an acknowledgement that people going through the protection order process have already been through a lot. They've been through an abusive situation, and sometimes the courts can further exacerbate that. And so there's also several changes for the courts, and there's judicial training as part of the bill as well, to try to make the process as smooth and less and not further compounding trauma as it can be for survivors. I'll also add, I meant to say this, but there's also an acknowledgement in the definitions that we'll talk through in a minute of just different family and household structures, and also an incorporation of best practices just across the state. Now, going through the definitions, I really encourage, a lot of definitions changed and a lot were added. So I really encourage you to go through the statute just so that you're familiar with some of that. So there were several updated definitions. Abuse was updated. Notably, coercive control is now included in the definition of abuse. In the definition of domestic violence. In addition to adding domestic violence, I'm tripping over my words. In addition to adding coercive control to the definition of domestic violence, the imminent was removed from the definition. So there no longer needs to be a risk of imminent harm. And there's other changes. So you really should familiarize yourself with that new definition. Family and household members also changed. It now covers instances where the respondent has harmed petitioner's child and did not previously meet the other definition. So it applies to all persons related by blood or marriage, or who currently or formerly resided together. The previous law only applied to adults with such relationships. And it includes a parent's intimate partner and children and a person who has acted as a legal guardian. There also were changes. I'm not going to go through each one of these just in the interest of time, but I just want to note intimate partner was updated, non-physical contact was updated, sexual conduct was updated, stalking was updated, as well as unlawful harassment. Now for unlawful harassment, it can include a single act of violence or threat of violence that is a crime or involves weapons. So just note that also. In terms of new definitions and additions, consent has been added and defined. And let's see, firearms, full hearing, full protection order, possession, temporary protection order, and coercive control, which I'll talk about in a minute. So coercive control means a pattern of behavior that is used to cause another to suffer physical, emotional, or psychological harm, and in purpose or effect unreasonably interferes with a person's free will and personal liberty. In determining whether the interference is unreasonable, the court shall consider the context and impact of the pattern of behavior from the perspective of a similarly situated person. And coercive control does not include protective actions taken by a party in good faith for the legitimate and lawful purpose of protecting themselves or children from the risk of harm posed by the other party. I will add that if you go into the statute, there's several examples, which are not an exhaustive list, but because this is somewhat of a new concept in the legal system, the full definition is quite a bit longer. And there are examples. A person does not necessarily need to fit within all those examples to meet the requirement of coercive control, because this is the overall definition, what I have on this slide. But it's worth going through the examples, just because this is kind of a somewhat new concept that we're all getting used to and familiarizing ourselves with. And then I'll turn it to Sara for jurisdiction and venue.
Thank you. Okay, so I'm just going to briefly talk about jurisdiction and venue, as well as filing and service. We just kind of want to make our way through the process up until that initial filing happens. So, and then we'll turn to the forms. So first with jurisdiction. Thanks, Elizabeth. So I actually kind of wanted to ask, are all the facilitators here today Superior Court facilitators? And Kaylee, I don't know if you can just answer that, or. Sorry.
Oh, there we go. I'm meeting at the same time. I apologize.
No, I'm sorry.
No, it's okay. That's why I turned everything off. Yes, everybody that's on is with Superior Court.
Okay. Okay. So there's now concurrent Superior and District Court jurisdiction for all the protection orders, the exception being vulnerable adult protection orders. Also to note, extreme risk protection orders, you can get temporary orders in District Court, but final orders and hearings have to take place in Superior Court. And these matters are no longer heard, and these orders are no longer issued through municipal courts. I was going to talk a little bit about specific situations or times when a case is required to be transferred from District Court to Superior Court. But I think in the interest of time, and since you all are facilitators at Superior Court and will be receiving cases and not necessarily transferring, I can probably kind of skip over that. But that slide is included if you want to look at that later. So looking at venue. So there are now uniform venue requirements for all 6 types of petitions. And this is an example of what Elizabeth was describing in terms of not only consolidating, but also creating consistency across the board with all of these. There are a lot more options in terms of where a petitioner can file. So they can file where they reside, where they live. They can file in the place where the act in the petition occurred, where a child who is going to be protected by order resides, where the petitioner used to live, if the reason they have left that place is a result of the act in the petition, the abuse, or in the court that is nearest to them, even if that's a different county than where they currently reside. So this really expanded access for petitioners in terms of getting their cases started. So now looking at filing and service, again, a big area in terms of expanding accessibility for parties. So one of the most important reforms that came from this new statute addressed a barrier that a lot of petitioners and people who worked with petitioners, perhaps all of you, had noted over the years. So now the law provides that even if there is a qualifying domestic violence relationship between the parties, so a qualifying intimate partner or family household member relationship, the petitioner should seek a domestic violence protection order, but is not required to, and can in fact seek a sexual assault protection order, stalking protection order, or anti-harassment order. So this addresses a really big problem, which was previously, if you had that qualifying relationship, you were strictly required to seek the domestic violence protection order. And if you came to court seeking a different order, the court would essentially tell you you've asked for the wrong order and send you to start all over again. And I know all of you working with petitioners have a very clear understanding of the time, the effort, the sacrifice, the emotional toll it takes for petitioners to prepare the paperwork and seek these orders and go through this process. So this is a really important and significant reform. Sort of other areas where access was expanded, and as Elizabeth said, we're just doing a really brief sort of high-level overview because our understanding is the more important, kind of the more important or relevant part for all of you is really talking about the specific forms. But a few things to point out. So now minors 15 or older can petition for any type of protection order other than the vulnerable adult protection order. Someone can file on behalf of another person who is unable to file for themselves, even if they are not found to be a vulnerable adult. If a petitioner, there are a lot of options in terms of where a petitioner can file now, but if they happen to file in a court that does not have subject matter jurisdiction, they are no longer responsible for starting over, finding the right court. The court they go to will enter findings establishing the correct court for them and will direct the clerk to transfer the petition to that correct court and then provide notice of that transfer. Electronic filings for protection orders are to be made available at any time to increase accessibility and better address sort of emergency situations. And so that's where the electronic filing really comes in. And then petitioners must be provided a copy of or emailed the service packet so that they have it immediately following their hearing for temporary orders until the respondent can be served. And then parties, attorneys, and witnesses may now sign sworn statements or affidavits, declarations electronically. And for the most part, that was previously allowed. But again, I think as Elizabeth noted, there was not, it could depend on what court you were in, and there was not a consistency there. The last thing I'll mention is there are a couple of deadlines. Again, you're all working with Superior Court, but by January of this year, and then by January 1st of 2026 for district courts, All petitions and other filings in connection with a petition are allowed to be submitted by way that is preferred by the petitioner. So that could be in person, electronic submission, or by mail. And then for Superior Courts, again, the deadline is past January 1st. For district courts, it's January 1st of 2026. The recommendation is courts should have systems in place that allow for enrollment of the petitioner to electronically track and receive notifications through text messaging or email regarding the progress of the petition, and then for the respondent to be able to enroll for similar notifications in the case as well. And just finishing up here with service. So under the prior separate statutes, all 6 of them specifically required personal service of the petition to be attempted. And in addition, the only kinds of alternative service authorized by the statutes were mail or publication. So there were no specific provisions allowing for electronic service before, but now this new statute, 7105, largely allows for electronic service, except in a very specific situation, which is noted on this slide. So required personal service by law enforcement is required when there needs to be a surrender of firearms, when there needs to be a transfer of the custody of a child or children from respondent to the petitioner, when the respondent will be vacated from the party's shared residence, or if the respondent is incarcerated. And it's important to note that once these situations are resolved, so the respondent has left the residence, the custody of the child has been transferred, then service can be done electronically. And then also within the statute, it notes that service of protection orders must take precedence for law enforcement because that, again, depending on jurisdiction, was not always the case. Oops, I think we have one more. Yeah. So there are, again, those limited circumstances where you have law enforcement required to do the service, but for the most part, electronic service is the preferred method, and it's prioritized by the statute. So electronic service can be email, text message, or social media. Not only can that be done by a third party, should the petitioner choose, but that can be done by law enforcement as well. So law enforcement can utilize this too. Court authorization is not required unless personal service was initially required and couldn't be done. In those cases, electronic can be authorized, and the court can authorize that after a simple request and finding of good cause, but there doesn't need to be a formal motion made by the party. And then for confirmation of service, verification can include a read receipt, a response from the respondent, a sworn statement from the person who affected service, verifying the transmission, and any follow-up communications like email or telephone contact that may have occurred. And then if the respondent appears at the hearing, that will do it as well. So I think at this point, we're ready to transition to looking at the forms, and we wanted to have a majority of the time for that. I see one thing in the chat. Oh, okay, that's just Kaylee. But maybe if it makes sense to just kind of pause right now. Are there any questions about sort of what we just went over, or you know, this was sort of our agenda and what we understood would be sort of most helpful. But if there are specific questions or other ideas, we want to make sure that we're catering this towards your specific needs. Okay, but yeah, I guess we'll just, oh, here we go. So how do you explain the difference between a protection order and a restraining order? Okay. Do you want to go ahead, Elizabeth, or?
Oh, I can't, either one.
Okay, I'll go, and then I'll be quiet for a little bit. So, protection order is a civil order. So a protection order is what is issued by the civil court, and all of those orders that we talked about the sexual assault protection order, domestic violence protection order, anti-harassment protection order, stalking protection order, extreme risk protection order, and vulnerable protection order. Those are all civil protection orders. A restraining order is a different type of order, and that term, and it's really just, it's really an issue of the terminology. So I'll have, Elizabeth has more experience in this than I do, but a restraining order is something that is used in oftentimes in a family law case. And then you actually have the third kind of order, just to make it even that much more confusing. In the criminal cases, you have what are typically just referred to as no contact orders.
Yeah, and I'll just add, for protection orders, they are their own thing. It's a proceeding that is based just on, or not just, but where it's just about the harassment, or it's just about the sexual assault or the domestic violence, whatever the name of the order is. Restraining orders are part of another existing case, and they don't have to be about domestic violence. If you have a case against someone, and in family law, you get restraining orders for, financial restraining orders. I was in court one time and somebody was getting a restraining order against their neighbor to restrain cutting down a tree, like while they had this property dispute pending. Like, you can get a restraining order is just anytime you have another case and you want somebody to not do something. And so it's a lot of times it includes domestic violence, and it can be very similar to protection orders, but it also can be really anything that you don't want somebody to do while you have another case pending or as part of the other case. Okay, it looks like are there any other questions before we go on? Okay, I'm going to keep sharing screen, and please feel free as we're going through this, just pop in. That was kind of the more formal part, and then we're going to be going through the petition. Please feel free to put it in the chat, or just even, I think we have a pretty small group. Yeah, 28. Just feel free to unmute, give the questions we're going through. So we're going to go through, oh, I don't think I forgot to actually start sharing screen. Let me do that. Okay, can you all see the court website right now? Did I do that right? Okay, good. So these are the protection order forms. I just want to know, a lot of these came out in January or revised. So forms committee has been very busy. We're going to talk about the petition and the pre-filing forms. I did just want to note that they're all on here. And I don't know what your practice is if you have printed forms you hand to people. But in case you do want them on here, there's both PDFs and Word. Word is nice because you can edit, you can get more space. Some of the, as you'll see as we go through the petition, some of the sections, sometimes people need quite a bit more space, like if they're talking about the most recent incident of abuse or something like that. So downloading the Word form can be nice, just letting people know that's an option for them. And just wanted to note how many new forms there are here. So familiarize yourself with this. This is a resource. I mean, look at all of these. These are all pretty new or updated recently. So we're going to, and hopefully I tried to have them. That's the petition. Hold on. I had it ready to go. We are going to go through the pre-filing forms just quickly. Here we go. We're going to go through kind of the two shorter ones first. So just wanted to first note the law enforcement information sheet and the confidential information form have now been merged into one form. So that's here. That has to be filed as well. And so just wanted to bring your attention to that it's now one form. It's pretty self-explanatory, just entering in all the information that needs to be entered on here. Mainly just wanted to draw your attention to that. Sarah, do you have anything to add for that form?
The only thing I would add is that this form is not accessible in the way everything else that is filed in the case is. This file is strictly sent to law enforcement, and then also not part of the accessible court file. So it can be a concern for petitioners because there's so much identifying information there.
Yeah, that's a good point. And they don't have to serve this on the other party.
Right. The other party does not get this.
Close that one out. The other form we wanted to show you is the motion and declaration for fee waiver. So it's one thing that came through in consolidating all of these is basically there should be no fees for anything other than an anti-harassment order. If somebody is seeking an anti-harassment order, well, there's a few other exceptions that we'll go through. But so if somebody is indigent, there's certain situations in which they shouldn't even need to get a fee waiver because there shouldn't be a fee associated with filing. We just want to note that there are certain situations in which somebody will need to demonstrate, if they're indigent, that they're unable to pay to get a fee waiver. And if that's the case, they're going to have to do this fee waiver form. So, they, like before, do the financial statements. Wanted to draw your attention to this section. So this is where, in these situations, there is no filing fee that can be applied. So if these situations apply, then a person should not be needing to do a fee waiver form. So they do need to verify that these things apply here. And I think that's everything for this form. Sarah, do you have anything to add?
Yeah, I don't think so. Just that now I think it's probably going to be the exception that someone is having to pay a fee or prove indigency for it than the rule. So that's a switch from before as well, which is good.
Yes. So then with that, we'll start going through the petition here, and we're just going to take this section by section. So Sarah, I'll turn that over to you. Just scroll through.
So as Elizabeth mentioned, oh, okay, great. Maria, quick question about the waiver of filing fee. Yes.
So I just wanted, can you hear me?
Yes.
Excellent. I was just wondering, do you file that before you file for the petition?
So it will get filed at the same time.
Okay.
And I think, my understanding is it would be filed at the same time as the petition when they're initially seeking probably a temporary order, or at least just initiating the case. But you can also always check with your particular clerk's office if they have, a specific or different procedure. But I think it could just be filed at the same time.
Wonderful. Thank you so much. I appreciate it.
So for the petition, kind of like what Elizabeth had mentioned earlier, so there's one form. And I will say, if we do hear one consistent complaint, it's that it's long. And it is long, but that's because it's all you need. It incorporates everything. So most of you have probably been working with these already. But we're just going to go through, and then if there are specific questions, please, just like Maria did, feel free to speak up. Oh, Whatcom. We do not charge a filing fee in Whatcom County Superior Court. Do other counties charge?
Is that for anti-harassment orders or for protection orders? For all of them. Interesting. Okay. Yeah.
Well, that's great.
Yeah.
I mean, no court at this point, no court should be charging for any protection order other than an anti-harassment order that does not have a petition that describes any of the conduct listed that Elizabeth pointed out. But the fact that they don't charge for anything is wonderful. So at the start of the petition, the top is the same, just with the parties' names and the court. And then here you've got you have all 6. There's only 5 there. Is the last one on the next page. Is ERPO included on this one? No. So you've got your choices for the 5 different orders: anti-harassment, vulnerable adult, domestic violence, sexual assault, and stalking. So your petitioner is going to just check the one that they're seeking and that they think best fits their situation. And you'll see here on number 2, says if more than one fits your situation, list any additional order types here. So I think the important takeaway from this, it's 2-part. One is what I already covered. If they quote unquote get it wrong going to be turned away. They're not going to have to start over. They shouldn't be penalized. And the second is, it's really going to be, the court's going to review this. They're going to see and consider the preference of the petitioner in terms of what order they want, but they're going to make a finding as to which is the appropriate order. So an example is, I'm working with someone who has a case right now. The petitioner went in and asked for an anti-harassment order, but in fact, what the court ended up doing was issuing a temporary sexual assault protection order, and it's continuing as a sexual assault protection order case. Then just the person who's going to be restrained, the respondent, their age. You can still include children, minor children that you would like included in the order. One thing that I think is different is that you can include minors who are members of your family or household, even if you are not necessarily the parent. And I'm not sure if that's new, but. And then you can also, as we mentioned, petition for someone else if they're a vulnerable adult, obviously, but even if they're not legally a vulnerable adult. So that is here. If that person is unable to petition for some reason. So for example, maybe that person is currently incarcerated. Maybe that person is currently hospitalized. And just unable to go through this process, but there's still an emergency need. And then your service address, interpreter. And then here's how you indicate how the parties know each other. And again, this reflects what Elizabeth was talking about with the definitions, an expanded definition of intimate partner and family or household member. And then why Washington has jurisdiction. So why are you filing in this county? And we kind of went through that with the venue. And then here, this is not new, but it's a really important part that sometimes I think sometimes gets forgotten and left blank. So both parties are responsible for indicating if there are other cases, if they have other cases or matters pending. That cannot preclude a petitioner from getting a protection order or from having access to this process, but the court still needs to be aware of it. So putting any other cases involving the same parties here. Sometimes people will also put, if they have filed a police report, they'll include like the police, the case number and the particular law enforcement agency. So it's technically not a court case at this point, but it's a pending investigation. And then I'll do this and then I'll turn over to you for a little bit, Elizabeth. So, and then this is also not new. So when a petitioner initially files, they can ask for a temporary protection order. So that means an order that would be put in place that day without any notice at that point to the respondent. And then that temporary order would stay in place until the next hearing. And between then and the next hearing, the respondent would get served notice of the petition, the temporary order, and any sort of restraints or restrictions that have been put in place. So here, the petitioner is going to indicate, do they want a temporary protection order immediately pending the next hearing? I've never worked with someone who didn't. I mean, I suppose it's possible, but typically there's a real safety risk happening. And so a temporary order is necessary. Immediate weapons surrender. So do you want the order to require that the respondent give up all firearms and dangerous weapons? Again, the petitioner would be in the best position to know what the respondent has in terms of firearms and weapons and what they're at risk of. So they can make that determination, or they can make that request. The court will make the determination. And then in order to get that temporary order, they have to explain why they need that temporary order. So what harm or injury could occur if an order is not issued immediately without notice. And so as we certainly when we kind of do this sort of training with advocates and other attorneys, we sort of go into the more we kind of go into a more explanatory process of what is helpful to put here, what kind of information is helpful to put there. I know as facilitators, you're not giving legal advice, but I don't know to what extent you're working with petitioners in actually drafting statements like this. I would like if anybody wants to sort of share. Is it helpful to talk? Is it helpful to talk about that for all of you? I guess is my question.
Sure, I would love to hear what other people's experience has been with this. Personally, I can share a little bit. I just have to do a protection order, I basically helped the client explain a little bit, because it seems like sometimes their thoughts are really scattered, and just helping her focus a little bit more on what she was trying to say. I was still helping her basically still have her voice. So her voice was still heard in the comments, but at the same time, I was helping her word certain phrases, maybe slightly different, just so that it would be more coherent and more, linear, or I don't know.
Yeah. That makes a lot, yeah, because, like we talked about, most of the time it's an emergency situation and someone is really at risk. And so their ability, like you said, to be really coherent and linear and clear can be really impacted. Well, I guess all I'll say here is, a lot of times people will just say, they can talk about what happened, the most recent incident or past incidents that led them to ask for this order. But also, oftentimes they are worried about what the respondent's reaction is going to be when they find out that they're seeking a protection order like this. And so knowing that.
May I interject?
Sure.
This is Glenna from Chelan County. I tell the folks that the respondent will get this and that they'll get to read the whole thing. And I also encourage them to write down on the paper what they've been telling me. And so sometimes I will parrot back to them. I heard you say this. Is that what you want the judge to know? And I'll say, okay, this is where you write that. I tell them that this statement is what the judge needs to read to decide whether or not they will get their order and what kind of order they will get. So I just try to parrot back to them what they've been telling me and encourage them to write it with the knowledge that the other person will read it.
Great. Thank you, Glenna. This is really good. I hope, if you have like information and practices like that to share, you'll do so, because this is also an opportunity for all of you to, share best practices and learn from each other. So we definitely don't need to be the ones talking the whole time. Okay, well, do we want to move on? Elizabeth, do you want to take over for a bit?
Yeah, we can just continuing to go through. These are the various restraints everyone can or in the protection order. Just wanted to note for the exclude and stay away section, there is a write-in option down here. And if you have the Word version, you can add additional ones too in case something is not in here. Sarah and I were talking yesterday about some of the other places that have been written in, like maybe the protected person's gym or just anything. And so just wanted to note that there can be additional things written in here that the petitioner wants the respondent to stay away from. Again, these other things added in are requests that petitioners can make. The intimate images is new. And I can't remember if we've gotten to abusive litigation yet.
Not yet.
Down below. Okay, sorry, I can't remember where everything is. So that's new. That's something, and again, this is kind of part of the modernization, and also just a recognition of the ways that technology is now really used a lot of times in these cases. Electronic monitoring is an option. You can get evaluation and treatment. You can get personal belongings, these things. So abusive litigation, we just wanted to note too that there is a separate statute, and that abusive litigation is is defined. And so make sure it fits in that. It's not just that somebody filed something that somebody didn't like or something else. And then we have the pay fees and costs. I don't know if there's any questions on that section before I keep going. Okay, just going to keep going. There's the surrender weapons, and we'll get to the attachments after we go through this, but just wanted to note there are several attachments that are part of this long form. So the firearms identification is at the bottom of the form, and we're going to get to that. But I just want to note that if they're requesting that weapons be surrendered, there's more information there that they can give to the court. Custody. So just note this is the protection order can address these issues. And one of the changes that is written into the statute too is that relief cannot be denied in the protection order proceedings just because it's available somewhere else. So it's not okay for the court to just tell people they can't make a determination because they should be filing a family law action. If they have a valid case for protection order action and there are children involved, they can ask that the visitation issues get addressed here, even if they're going to be filing a family law action or something else later. These sections were kind of standard before, so just different issues when they're kids. I know pets a lot of times are very important to some of the survivors I've worked with, so this is here as well.
I have a quick question, Elizabeth.
Yes.
Sorry for interrupting. Regarding the request for like custody of children, pets, etc., if they do file a family law case later, would that supersede any court order then that would be in a protection order case?
So the family law section, the family law cases have the same section that we went over up here where you have to reference any other orders. So if they're filing a family, where is it? Sorry. It's always harder for my brain with Word. There we go. Family law petitions have a similar section here. So if they subsequently file a family law action, they will have to list that there is a protection order. And then oftentimes what happens if in my experience, if the person wants to continue having a protection order, they can have the protection order case consolidated with the family law case. So they can, oftentimes, I've mainly practiced in King County. In King County, it can take a year to get a trial on a family law case. And so usually by the time you get to family law trial, you're facing renewal of the protection order. What you can do then under the family law action is ask for a renewal under the family law action. The family law, to answer your question, the family law case will consider the protection order and then make some sort of references in its order, either incorporate the protection into a new order or something else. That was a good question for bringing that up. Yeah. And that happens a lot in divorce. A lot of times people file a protection order first. And then later, kind of some of those issues need to get incorporated into the family law actions. Okay, sorry, I'm just trying to get back down to where we were here. Okay. The vulnerable adult section, law enforcement, there's the length of the order. Oftentimes, if there's children, it's going to be 1 year, although it can be renewed for more than 1 year with children. And that's something that does happen in family law. Just to go to your question, this was a good segue. A lot of times at the initial DVPO hearing, if there's kids, the court will enter the order for 1 year. But then once you can have a full family law trial, there you can get an order at the family law trial concerning the children for more than 1 year.
Elizabeth, can I add one thing?
Yes.
Or I guess two things to clarify, and this may be obvious. It's when the child, when the respondent has custodial rights over the child. So if it's just a child who resides in the household, but the respondent doesn't have any sort of custodial rights, then there's not that 1 year limit on the order. And then the court can issue an order of what's called a permanent or referred to as a permanent or a lifetime order. And that is specifically an order for 99 years. So that's the maximum length.
Thank you, Sarah. Yeah, those are both really important. If it's not the respondent's child, then the same considerations don't go in. And as I understand it too, with that 99-year, law enforcement needs for their system, like some sort of specific date to enter in, because I've unfortunately made that mistake in the past. So there does need to be like an actual year written in.
Yeah, so they codified that 99. years.
Yeah. Okay, this section I wanted to talk about kind of in relation to what Sarah said as well, and I'm curious what you guys have done and what works. When I'm giving this training for advocates, what we like to, for this section, with most recent incident, and this was consistent with the previous forms too, the court wants to know what the most recent incident is. And I know you can't give legal advice, but just as information too, what I've found is that it's important for people to contextualize the most recent incident, because sometimes the most recent incident isn't the scariest. So, you know, maybe most recent incident is respondent showed up at petitioner's doorstep and he was agitated and yelling, and that's the most recent incident. That in and of itself, if without further context, may be borderline for the court. But if previously, you know, 6 months ago, the respondent showed up at petitioner's doorstep and was agitated and yelling, and then he broke her arm, that's really important context that you want to make sure you have in here. So it's like you have the most recent incident, but then you also have why this most recent incident was scary. Because a lot of times that context is very important. So that's here. And I know you can't give specific advice here, but I think just giving information about making sure they are utilizing that part effectively is important. And I'll just add too, if it's in Word, you can either add additional lines in here so that you can use as much space as you want to, or if it's a written petition, then there can you can add on an additional page as well. Past incidents, usually it doesn't seem like people have a problem with that. I will say I always encourage people, anytime people can, if they know the dates or the season or the year, people shouldn't make things up if they're not sure. But if they do know, it helps to have like the dates and as much specific information as possible. I also encourage people to use kind of explanatory language instead of just saying what it was. So instead of just saying like, there's been a lot of emotional abuse, saying he calls me such and such names and does this, that, and the other. And same with it. It's better for people to not make conclusions because the court wants to make those conclusions. It's best for litigants to give as much information as possible about like specifically what happened and what the facts are. Medical treatment, they want to go through that. Any suicidal behavior. Substance abuse, minors, and just wanted to note this too, there's additional evidence that can be attached. Some courts are also allowing submission of video evidence too, and you just kind of have to check about how they want to do that. Now, just wanted to point out too, so at the end here, you're still not done. So the petition's done. We have this section here that has some definitions, which is really helpful. So that's there is a resource, but then we wanted to also note that some of these attachments are going to be needed. So you have this vulnerable adult attachment that may be needed. I'm going to keep going through here. Or actually, I should have paused. Were there any questions up the previous section? Or comment? And I'm going to keep going in. Sarah, you jump in too if I'm missing something.
Okay.
You see that we're close to time, sorry, and I don't. Okay, we have this child custody attachment. This is standard in family law actions too, just so that you know too. This is just for the court because there's times when sometimes the court doesn't have jurisdiction over the children. And so these questions is kind of, and sometimes there's other people that should be notified. And so this is kind of just to help the court make those determinations and get the information that it needs before making an order that's going to include the kids. Wanted to also flag that sometimes the Indian Child Welfare Act applies. This basically only applies if a non-native person is petitioning on behalf of a child that has native ancestry. And so that's just something to be aware of. If the child has native ancestry, it's not going to apply if it's a case between two parents. But if there's a non-parent petitioning and including the kid, which I think would be rare, somewhat rare, in protection order cases, but it could happen. So you're going to want this form here. If you're working with someone who's also filing for a guardianship, this may, because this ICWA comes up a lot in those cases, so this might apply there. And this is the other one I referenced previously, the firearms identification. So this just gives additional information that's going to help with that. And then the part that's really helpful at the bottom, because not all survivors necessarily know what different types of firearms are called, but they know what it looks like. And so this part is just kind of helpful too, where you can go through with somebody like, okay, does he have something that looks like this? Does he have something that looks like this? And that can be helpful because not everyone necessarily knows the names of everything. And with that, that's the petition. I'm going to stop sharing and see if there's any questions in the last few minutes we have here.
Or if there's another, I know we only have a few minutes, but if there's another specific form someone has run into and has questions about, we're happy to address that too. Again, we just kind of went to the stage of filing and initiating the case for today.
I have a question, and I don't know if it's something you can answer, but I noticed last week, or maybe the week before, I had a Spanish-speaking person come in and I was printing out the Spanish forms, and I noticed that there's not a temporary order in Spanish at this time. Do you have any suggestions for that? I just kind of printed out the instructions in Spanish and then the English version and kind of tried to give her some, suggestions on someone who could help, like services that we have in the area that could possibly help her translate that.
Yeah, I'm going. I know. Oh, go ahead, Elizabeth.
No, please.
No, I was just going to say that I believe there are requirements that of the clerk or the court to have certain forms translated and available, but I don't know that off the top of my head. I guess I would look at the statute and be happy to get back to you, but I think that should be available. I think the intent would have been for that to be available.
And that's what I thought too, but I only saw the final protection order on the court forms website as being translated. And typically in our county, when they file the petition, we just automatically do the temporary to get them to the hearing. So that's come up a couple times now, which makes it a little difficult trying to give them the service that they need.
Sure.
I'm seeing as well that the temporary protection order is missing. I have a contact with AOC that I can reach out to find out either the status or progress of that for you too, Casey. So I'll try to get that information.
Okay,
to see what the plan is. Yeah.
That's great. Thanks, Kaylee.
Well, I see it is 1 o'clock, so we got right through there in time. Sarah and I are both available to stay later if anyone has any other questions. Otherwise, we'll let you go.
Yeah,
Thank you, guys.
Thank you for having us.
Thank you.
Thank you. Thank you, everybody, for joining us. I'll keep the recording on as well for just a little bit, just in case there are some more questions. I think we're losing everybody though, so.
I wanted to say thank you so much. This was excellent. I really appreciate it. I'm new as a facilitator, so for me, all this information is super helpful. I have a ton more questions for you, but I was wondering, do you have any email or something that I could maybe keep in touch with you?
Let me put that in the chat.
Yeah, and I forgot to put, that's in the slideshow, which is going to be shared. I forgot to pull that last one up. So I apologize for that. I'll just put it in the chat. That's easier at this point.
Awesome. I can also include your guys' contact information when I send out the PowerPoint later too.
Oh, good.
Hi, Christina. It's good to see you too.
Maybe one last thing, there's only a few people, but one last thing I'll say as well is we have, SCLC has a legal line. So it's basically a number or an email that you can use. And we do technical assistance for advocates and other providers. We assist them through that as well as survivors directly, but that's also a resource you can always use, and it's answered by our attorneys.
Oh, wonderful.
And I'll make sure Kaylee has that
Thank you.
that information as well as Elizabeth and my emails.
Great. Thank you.
That's great. Thank you so much. Really appreciate it.
I'll throw it in the chat, but also make sure Kaylee has it.
And thank you, Kaylee, for putting this together. This is awesome.
Of course. All right, I'm going to go ahead and turn off the